12715 Ahmed versus Bandal. Counsel, make your appearances.
Tanika Mann, counsel for plaintiff, Mr. Ahmad.
Sarah Bonow-Meyer, here is defense counsel for Amarpreet Bahandal.
Okay, we're here on a motion to strike counter affidavit. Why don't we get started?
Judge, since their names are not showing up, they're going to need to announce when they speak.
Okay.
When they speak for a while. Thanks.
Whenever you speak, you'll need to say your name, Tanika Mann for the plaintiff, and then speak. And then Ms. Myers, when you speak, you'll need to do the same thing.
Thank you.
Will do.
Yes, sir. This is Tanika Mann for the plaintiff. Defense counsel has filed a counter affidavit in regards to our affidavits, and we filed a motion to strike on the basis that there is no reasonable notice on the basis on which they intend to controvert their information at the time of trial. Under United Blood Service versus LaGuardia, the counter affidavit must include qualified expert opinions along with the fact on which the opinions are based upon. The defendant has submitted a response to the counter affidavit in the motion to strike on Friday evening. And the DC is trying to shift the burden. As under 18.001, the burden is on the defendant to provide reasonable notice. The response, defendant has stated that the expert has provided only his opinion in expert testimony, and that the need to require the basis or the relevance on his opinions must be resolved by deposing Dr. Moss. That is incorrect, as the basis should be included in the counter affidavit as stated out by 18.001. Robert Moss had stated in his counter affidavit on several separate occasions that his counter affidavits are strictly based upon his years of experience, his experience with dealing with injury patients. Also, in the response, the DC Defense Counsel has also stated that the basis of the counter affidavit are based on the expert opinion. We should not have to depose the expert in order to determine the basis on which they intend to controvert or the facts surrounding the opinion. It states that knowledge, skills, experience, training, or education should exist in a tier of fact and not be the basis of the counter affidavit. Mr. Mott continues to state that the treatments provided to my client, Mr. Mead, are not recommended beyond the second week of treatment. He failed to provide any type of findings, any type of study, any medically accepted guides, or any factors or basis to align his personal opinion. Throughout this, Mr. Mott stated, I recommend my experience I utilize in my professional opinion. He provided his opinion, but this is vivid proof that he does not back his opinion with actual facts or findings to correlate. In Anderson versus Snyder, the court stated that expert testimony comprises only conclusions and does not include any basis or reasoning are insufficient. In that factor, Mr. Mott stated his opinion throughout the counter affidavit, but failed to provide any factual basis on which he intends to controvert that information. Mr. Mott continues to state regarding the reasonableness of charges. He based that his experience with fee schedules validates his opinions on the charges that he provided. He stated that without any actions, that these are the list of alternative charges that should be charged for each service. Again, he failed to provide any specific authority on which the basis of the alternative charges come from, any underlying factors that are considered with these alternative charges, or whether or not where these alternative charges come from, whether they're insurance-based, out-of-pocket, provide a discount, Medicaid, etc. 18.001 states that the counter affidavit must provide reasonable notice on the basis that it intends to controvert, and Mr. Mott failed to do so. Again, under United Blood versus LaGuardia, the counter affidavit must include all the prerequisites. It must include the qualified expert, the expert opinion, and the facts on which the opinion is based. Mr. Mott's counter affidavit fails to provide any factual evidence for his opinion. As stated as such in the response, defense counsel stated that he has provided only his opinions in this expert point, and that if I required or needed the basis were relevant or any type of reliability on his opinion, that I should do so by deposition, which clearly states that the facts were not indulged in the counter affidavit as outlined in 18.001. Mr. Mott counter affidavit validated that Mr. Mott, opposing counsel, consisted of a conclusionary statement. He only provided his opinion, did not provide any factual basis, did not provide any ground on which the charges are reasonable or unreasonable, did not provide any basis or any type of factual information to provide the counter F or the alternative charges on why these measures should be changed or altered. The testimony provided on the legal conclusion, and that is insufficient for the reason that we're here for today. So I ask that the defense, that today that the plaintiff, that the defense counter effort be stricken due to the fact that there have been no factual basis to accompany the expert opinion. And without the factual information to accompany the expert's opinion, the counter affidavit is insufficient and therefore should be stricken.
Response.
Sarah Meyer for the defense speaking. Your Honor, kind of going through what plaintiff's counsel has said, the purpose of the counter affidavit is to controvert the factual statements or the statements made in plaintiff's original affidavit. That's the purpose of the counter affidavit, to review the affidavit and controvert it. The information that Dr. Mott relied on was provided by the plaintiff, provided by their own medical records. Dr. Mott has proven that he is a doctor with experience. He has over 15 years of experience in chiropractic care. He based his opinions based off of the diagnosis provided by plaintiff. If you review his counter affidavit, he states that several times. Based off the diagnosis provided by plaintiff or of plaintiff, he makes these decisions. And not to mention, he does state the factual basis, which he does determine his opinion. For example, when it comes to the re-examination of plaintiff, looking at each re-exam every couple of weeks, he states, in reference to the use of the level 3 re-exam, the CPT coding manual requires 3 key components. He does state his factual basis for making opinions. He is an expert, as he has 15 years of experience. With regard to the charges and the reasonableness charges, he bases off the fee schedules around the DFW area. He states that in his opinions. He states that the opinions are of his. He also states in the following part regarding passive therapies. He provides an article in the Philadelphia panel, which is attached at the end of it, the Philadelphia panel evidence-based clinical practice guidelines. He goes into it there. He names his sources. The Philadelphia panel, based on mechanical traction, he provides an article on that. He does provide information as to how he bases his opinions. Not to mention, he also provides a chart that breaks down each charge and what's reasonable in the area. He does provide that information. So he does give everything that he uses, plus he explains his experience in 15 years of practice to back up his opinions. Dr. Mott is incredibly thorough in his counter affidavit. He breaks down every single inch of plaintiff's treatment, from electrical stimulation, explaining and reviewing plaintiff's treatment, and going into, its pluses and minuses, why it does work in this case, why it doesn't work in this case. He explains that it is, for example, electrical stimulation-based therapy. He states that it is great in the short term for pain relief and increased spinal mobility, but after 2 weeks, it may be a bit of a dependence for the patient and for the provider. Regarding passive therapies, he provides an article supporting his opinions on that for when he does make any statements regarding passive therapies. Again, he provides the CPT coding manual in regards to re-examinations. At no point does he not give enough reasonable notice provided by 18001 to the plaintiff. He breaks down each aspect of plaintiff's treatment, each aspect of it, and provides his opinion, plus he provides sources of where he gets his opinion from. He is a doctor with 15 years of experience. He has plenty of experience to make any sort of opinion on this, and any opinion he's making is based off of plaintiff's own records. He's not pulling it out of the sky. He's pulling it from plaintiff's own records. I think that he has provided reasonable notice, and it is based in his experience and in the sources he cited. So that's our argument as to why the counter affidavit is reasonable. As far as it goes to the deposing of the doctor, at any point, plaintiff is welcome to depose the doctor. That's why we state that the motion is premature. They have not requested or attempted to take Dr. Mott's deposition to explore the foundations of any of his opinions, or
Counsel,
that, you know, or,
counsel.
Yes, sir.
So there's a couple things that I wanted to focus on. Part of his, I'm looking at his report right now. Part of his report talks about cash price. What does cash price mean?
I believe that's the price without insurance, Your Honor.
So if the person came in and just paid off the street.
Yes.
Okay, that's not the situation we have here, though, right?
I believe, I mean, it was likely that plaintiff treated under a letter of protection, Your Honor.
Okay. This is strange how he does this. Okay. And then the other issue you have is about taking the deposition. I mean, we all know that that's not how this works here. You don't have to take the deposition to be able to strike a counter affidavit. That's so I agree with Ms. Mann on that that's not appropriate, not necessary. Now, if you want to designate Dr. Mott as an expert and he's going to testify, then yes, she can. But in order to strike a counter affidavit, that's absolutely not necessary. That would totally undermine 18.01. I did kind of look at his report, and you know, it is pretty detailed. I'll kind of give you a choice here, and that is, first off, I'm going to strike the counter affidavit to the extent that it deals with any treatment besides chiropractor. So I think he's trying to counter. I always do like to like under Turner v. Peril. So I think there's an MRI and another bill. What's the other bill? MRI and anyway, the two non-chiropractic bills. I'm going to strike the counter affidavit for that. For the chiropractic, what I usually do in this situation is recommend you guys just do dueling affidavits. Have y'all talked about that at all?
No, Your Honor.
No, sir, we have not.
How do y'all feel about dueling affidavits?
I am not opposed.
Ms. Meyer? And I will say that, I'll go ahead.
Go ahead. No, go
I
ahead,
was
Your
going to say that I admit I am very, very strict on counter affidavits. So just, I don't know how many times you've appeared in my court or if you have appeared in my court before, but I am very strict about these.
Unfortunately, I have not, and I don't think I will be anytime soon as the current setting. But with that stance on counter affidavits, I would likely agree to dueling affidavits.
Wise decision. All right. So just so it's clear on the record, the parties have agreed to do to strike all the portions about the MRI. And who's the third provider? There's the MRI, there's the chiro, and who's the third provider?
It might be the radiologist.
The radiologist.
Yeah, radiology.
Yeah, for the radiologist,
Yes,
anything about the radiologist or the MRI, that's struck. For the part about the chiropractors, the parties have agreed to dueling affidavits. Dueling affidavits, as we know, allows the plaintiff to go forward with 18.01 affidavits that will be sufficient to prove up reasonable necessity, paid and incurred. Obviously, does not deal with causation. And the defendant will have the opportunity to introduce the redacted affidavit at trial to take out the parts about the MRI, but she will be able to submit that at trial. And if she decides to do so, she can call the doctor, Dr. Mott live. Is that an accurate statement of what you understand dueling affidavits to be?
Yes, Your Honor.
Yes, Judge.
All right, great. Glad we worked that out. If you want to go ahead and get me an order on that, but otherwise we'll just deal with that at trial. And Rhonda, are you there? Can you put a note in the system, agree to dueling affidavits? Agree to duel. I'm sorry, Rhonda, you there?
Yes, I'm here. Agree to dual affidavits?
Dueling affidavits, D-U-E-L-I-N-G, dueling affidavits.
Got it.
Okay. Anything else, guys?
That's it.
No, sir.
You guys be safe out there, and good luck, and we'll see you the next time, okay?
Thank you, Your Honor.
Thank you, Judge. You have a good one.
You too. All right, I think we next have Metro PCS Massachusetts versus Trenton Capital. Are both sides here?
I'm present on behalf of Martha's Vineyard Savings Bank defendant, Your Honor.
And what about your opposing counsel?
I believe Miss Moore looks like she's on.
She's trying to.
It looks like she's trying to get on.
And this is a motion to deposit funds, correct?
Correct, Your Honor, and it's not opposed. However, there and Miss Moore can kind of fill you in to the extent needed. There, I believe one defendant is no longer moving forward with any claims as to the interpleader funds, and that would be Trenton Capital. And we are having some, Miss Moore, I believe, can elaborate, but I don't believe Cobalt North LLC has been served yet. There's been some difficulty in finding a representative to serve that entity.
Ms. Moore, are you there? Ms. Moore, Linda Moore, are you there? Well, so for the interns, the 2 o'clock hearing is canceled, just so you know, the Short v. Myers case. So the next hearing after this one is 2:30. Did y'all get to read the 4 o'clock, the briefing for the 4 o'clock? Talked about, who all read that? Randy, Camille. Oh, Samir, I'm very disappointed. You didn't read it?
Sorry, Judge, working on the memo.
All right. Leela, did you read it?
I didn't have a second because of the lunch, but
Oh, that's right. That's
hold
right.
up.
Well, you guys will have some time at 2 when we have a break, so try to read it then.
Yes, Judge, thank you.
Judge, just as a reminder, we have class at 4 p.m., so we won't be
Ah,
there. that
some of
period.
you guys won't be there. Okay.
But if it's on YouTube, then we'll just watch it after class anyway.
Yeah, you can watch it after class. I think that's going to be a really interesting hearing. Miss Moore, are you there? Linda Moore, are you there?
Judge, I'm happy to step away and see if I can give her office a call. It does look like she's here. It's just technical difficulties. This is an unopposed motion, but for the other defendants, if that helps clear, I believe an agreed order was, a proposed agreed order was filed with the court.
Okay, yeah, go ahead. And I guess, why don't we do this, since Linda Moore is apparently having some difficulties. Why don't you guys go ahead and just submit to me an agreed order. If she wants to object to it, or anyone wants to object to it, then we'll just raise that in the future.
Sure, and it has been proposed, and we can refile it if needed, or it has been filed. The proposed order has been filed. We can
Just
refile.
email it to my court coordinator.
Okay, I think out of abundance of caution, this was set because of the other defendants and the service issue we're having, and really it's just filing or depositing the interpleader funds in the registry of the court for safekeeping until potentially dueling claims towards those funds are resolved.
Sounds good.
So we can definitely get that done, Your Honor, for sure.
Right. Well, she wants to come back. You guys, I'll be kind of on and off this channel for the rest of the afternoon. If
Okay.
if Miss Moore wants to come back on later on and do an actual hearing, that's okay too. I don't have a problem with that. She can just, you guys can jump on.
I'll hop off real quick and see if I can just give her a call and maybe hop back on and give the court an update to the extent I'm able to touch base with her.
Okay.
Okay. Thank you, Judge. I appreciate your time.
Thank you.
May I be excused for the time being?
You may.
Thank you.